Hi, so in this video we will be going through the company law paper of the June 2024 attempt new syllabus. Now this paper had everything in it: action, drama, everything, drafting of resolutions, massive amount of sums, extreme amount of situational questions, and it could be said that it is one of the toughest company law papers ever. So we will be quickly going through, and before that you also tell me in the comment section how was your company law paper. Now remember, being the most toughest paper ever, you can expect lenient correction, and a student has to strategize by getting a lot of other marks in other subjects to pull up their average. So let's begin with the analysis. I'll just take you why this new trend has started, where the first question is a massive, you can see such a huge question has come. Okay, it's going on at, students have to allocate time for reading the questions also. And just imagine I'm still on the question number 1, and then they start from the above paragraph, you have to answer a few. Okay, so let's see through what the question they have asked. They have said that there is a whole lot of information they have given, that Manoranjan, a young journalist, okay, he started a small business focused on website copywriting. Having taken the business to the next level, he shifted from writing content to having a team. He personally monitored in the year 2016. He made a media company. It goes on, then he demerged one of the business. So it's just the facts they have given. Okay, but the interesting thing is, when you go through this, you will realize he's talking about he had a merger, amalgamation, all those things he has given in that. Then they are further saying about the scheme of compromise and arrangement. So this is important. Okay, your question will be based here. Okay, it says that a scheme of compromise and arrangement, whether it is valid. Then they go on to give you that dividend was given. They have told that he has accumulated losses. So let's get into the questions and then we will search the answers. Okay, so what did they say? That examine whether the scheme of compromise and arrangement is approved by the requisite majority. Now for this, student have to know section 230 to 240, which talks about the mergers and amalgamation. That's a compromise and arrangement. In that they say that the requisite majority will come when there is a majority of number and 3/4 in value. Okay, in value. So a resolution is said to be adequately passed when majority number of members approve it who are representing 3/4 in value. So when we go here, okay, let's look at where the numbering game has been come. Okay, what they have given, that notice was given to all 1200 members. So there were 1200 members having these many number of shares. The meeting was attended. Now this is important, because when we do counting for to know whether a resolution has been adequately passed or no, we have to see the members who are present and voting. So even if there were 1200, only 900, so 900 will be our calculation, holding these many shares, and 420 members voted in favor, and 360 members voted against the scheme. The balance remain abstain from voting. So now if we want to know majority in number, okay, first we have to know majority in number. So whether it is there, answer is yes, because 420 approved it and versus 360. So yes, it is approved by majority in number. Now we will see it, they should also represent 3/4 in value. So 3/4 in value. So if we go to see the value of the shares, 44 lakhs plus, okay, your this lakhs, that's how much, 4 plus 2 is 6, 4 and 5. So I'm adding it up to know the total, how many value of shareholders were voting. So we add it up, we come to know it is 56 lakhs. And how many voted in favor? So around 44 lakhs had voted. So 44 lakhs divided by 56. So 44 lakhs divided by 56. Okay. So we will see it is a 78% consent has been given. So 78%, which is above 75%. So yes, we can say that the resolution has been adequately passed by 78%, representing 3/4 in value. Let's look at the next question. Now obviously you can have a different answer also, that's not to worry. Okay, we are just seeing from what is my perspective. Second, a group of creditors of MTR is not satisfied with the scheme approved, okay, because it was in a fraudulent manner. Now this is the next question from the paragraph, and made a complaint to ROC. So there is a group of creditors who feel that the scheme should be rejected because it is in a fraudulent manner. So let's because immediately on receiving, now the registrar, what did he do? Immediately on receiving the complaint, attempted during the business hours, okay, on this date, he entered into the premises and seized the records. But the company opposed on the contention that the registrar has no power to enter into this without a order of the court. Whether the contention of the company is valid. So what happened is someone complained, and on basis of the complaint, registrar just immediately entered and seized the documents. So if you read your inspection, investigation and trial, okay, with respect to that from section 206 to 229 talks about how investigation is done. So it says that a special court order is needed. Okay, special court order is needed by ROC to seize documents. So here, if they have just entered and they have done, it is wrong. Okay, so the company will be successful against the ROC. Next, they have said what is the maximum rate of dividend that can be declared by the company. So when we see your dividend sections 123 to 127, okay, read with the rules. Rule 3 and rule 4 is about dividend. What do they say? That the dividend rates are as follows, okay, of the immediately preceding years. And company had made a loss also, okay, of 74 lakhs. So very simple, what are they saying? That what is the maximum rate of dividend? So this was very simple, and I think every student must have got it correct. It is the average. The rate should not be greater than the average of the past 3 years. So if we do an average of this, you will get 12%. Okay, 10 plus 12 plus 14. Okay, so the average comes out to be 12%. Yes. So the maximum rate of dividend of the past 3 years, if we see, is 12%. So the maximum rate of dividend that can be declared is 12%, is an average of past 3 years. Okay, moving forward, we see what is the next question. Now we are still, imagine students going through this on the very first question and how detailed it is. Okay, what is the amount of available for declaration of dividend subject to the fulfillment of condition if they declare. So they want to know what is the amount that can be available for declaration of dividend. Now if you read section 123, they say from which all sources of dividend has been given. Sources of dividend. So it is your free reserves, etc. can be given, but only after deducting losses. So when we go back here, we see that they are saying that the company had made a loss, right? So you will have to deduct the particular losses as well. So here, so free reserves are there, okay, and the losses are there. So free reserves less your losses is the amount available for dividend. So you will have to say that after meeting the losses, that much amount can be distributed as dividend, okay, which is available in free reserves. Next question is referring to the provision of the Companies Act. Explain the managing director the formalities to be completed before and after shifting of the registered office. So nowadays this trend has come where they are asking one huge situational question will give, and from that they are asking sums of every chapter. Okay, asking questions of every chapter. This is from MOA AOA, your shifting of registered office. So for your what is the compliance to be done? Okay, so if you read your section 12, which talks about registered office, okay, and also you read your section 13, your MOA, which respects to shifting of, it's a amendment to the office clause, okay, the registered office clause. So that is there. So what all is the compliances? Obviously an entire important list has been given, but if you go to see INC, INC 22 is the form number that needs to be filed while shifting and the entire thing, and they need to take a special resolution. Okay, then so a procedural part, if you write your sufficient, then they write P Limited is a wholly owned subsidiary, okay, and wants to make an application for merger of holding with subsidiary under section 232 read with section 230, okay, in the normal course. This is section 230 to 232 talks about a normal method of merging, that is the NCLT route. Okay, the company Q is of the opinion that they cannot apply for merger under section 232, and it shall be mandatory for them to apply for section this under fast track mode. Is the contention of the company secretary tenable? Okay, so why are they spoiling the name of company secretary in the exam in this question? They are saying that a company secretary has given such a wrong suggestion. He is saying no, you a company which is if a holding wants to merge with a subsidiary, they have to only go through fast track merger. Answer is absolutely wrong. FTM is an option. It is optional method. So the company can very well do, and in practical life also we've seen holding subsidiary, if they want, they can go through the NCLT route under section 230 to 232. This is the NCLT route. So option is given, but it is not mandatory. Moving forward to the next question that they have asked. Now again, such huge questions. XYZ Limited was incorporated. So yeah, 15 minutes of time is very important here. Okay. So they have a dairy business. They had remarkable sales. Congratulations. Hence the board of directors approved the proposal to set up a new unit in West Bengal. Okay, fine. And also resolved to raise funds by way of issuing shares to public. So they're going for an IPO. Congratulations again. What is the question? Company intends to raise through equity shares. Okay, fine. You want to raise equity shares and get it. Let's come to the question. Okay. However, the company does not wish to issue prospectus every time. Now this is very important. Company does not want to issue each time they go for issuing the share. They don't want to issue prospectus. So there is a kind of a prospectus here which is issued, which is given in your section number 31. Okay, 31, which is about shelf prospectus. Sir, what is shelf prospectus? Shelf prospectus is a prospectus for multiple issues. Here a company can make multiple issues, and for that they don't have to file prospectus at every stage that they are issuing the shares. They just have to file a information memorandum. For that you have your PAS forms also. Okay, now moving forward, so this was your answer. They asked shelf prospectus basically. Now moving forward, they asked Sunrise Coaching Limited is registered in Singapore and it has no place of business in India. However, it is conducting online education courses, providing tutorials by charging fees to Indian students, okay, who have joined the course from India. The registered office is in Singapore only. Okay, what is the status of the companies under Companies Act? So now what are they saying? That there is an online tutoring company, okay, and it is abroad in Singapore only, and it is catering to Indian students. Okay, they don't have it has no place of business in India. So what is the status of the company? So the answer is it will be treated as a foreign company. Okay, foreign company definition, if you go to see section 2 subsection 42, that they say that listen, even if you have no physical presence but you have a digital presence, still you will be considered as a foreign company and you will have to comply with the provisions of foreign company under the act, that is all those forms with ROC of Delhi, etc. Next, then they are asking about your bio chemicals limited is planning for buyback. Okay, during the, but the company has defaulted in the, so very simplified question, they have defaulted and they want to go and has not even filed annual return. So it's a horrible little company planning to do buyback. The company seeks your advice, okay, as to when and how the buyback under these circumstances, how, when the company can buy back its shares. Now this is very important. Your buyback of the shares is for prohibition is given under section prohibition of buyback. It is given under section 70. So the company is prohibited. But what question they are asking further? When the company can buy back under these circumstances. So it is written that if a company has defaulted, then they have to make a remedy. They have to remedy. They have to resolve these defaults, and then they have to wait for 3 years. So 3 years cooling period is there. All this is given in your section number 70. So the first is, are they allowed? Answer is absolutely not. Second is, if they are not allowed, then when again they will be allowed? So after they rectify the defaults, then still they have to wait for 3 years. After that it will be allowed. Then the next question is about Global Service Limited is planning to issue equity shares to private placement, okay, to residents outside India. Fine, so we are making a private placement abroad. Now what is the question? You are required to elucidate the compliance with respect. So now even if you want, next time I think it's very simple, directly jump down to the direct question that they're asking and then read the situational question. It goes faster, you will be able to direct. So they're asking what is maintenance of foreign register, an option available if they want to discontinue the foreign register. So again, foreign direct question only we can write maintenance of foreign register provisions. You can write it is in your section 88. Okay, read with your rule 7 which talks about foreign register. Okay, moment you set up. So foreign register is a register which is set up abroad, which has details of all the shareholders who are residing in that country. It is deemed to be a part of the principal register. Every moment we create a foreign register, we have to inform the ROC, okay, in your you have to inform the in the MGT form MGT3, you have to inform the particular ROC that listen, this is a foreign register within 30 days, and every entry that you have made in that foreign register, within 15 days we have to make a entry in this duplicate foreign register. Okay, next, what is the, if they want to discontinue, so you can create also is optional, discontinuation is also allowed. You can discontinue it after you have transferred all the entries back into the principal register or another foreign register. Moving forward, referring to the provisions of the Companies Act, okay, whether the following amounts received by the company will be considered as deposits. Okay, so now the provisions of deposits have come, that Tiwari Exports Limited has raised how much? 12 lakhs through NCDs, okay, non-convertible debentures, not constituting a charge on the assets of the company and listed on a stock exchange as per the regulations made by them. Okay, so now the provisions of this is contained in your section 73, read with section 76, which talks about deposits, but more specifically it will be given in your rule 2.1, okay, C, which they tell you, which is about deposits, what are deposits and what are not deposits. Okay, so then they tell you that whether it is a not constituting a charge, so it whether it will be treated as a deposit or not. Next is and in the module also, in the very first question they have given you in the exceptions of what are not deposits. Okay, so those we will see. Then comes a leading fridge manufacturer received 2 crores from Ankit for supply of fridge, and appropriation was made after and appropriation of such advance was made after expiry of 390 days from acceptance. So will it be treated as deposit? Answer is yes, because if we get an advance for goods, all this is given in this particular thing only, rule 21C about deposits, that listen, if you get deposits for supply of goods and services, it is not deposits. However, if you have kept this money beyond 365 days, then it will be deemed to be a deposit, and the provisions of deposits have to be followed. Next, if we go to see, Lalit ceased to be a director by resigning. Okay, so he resigned on June 15th, and the company received so much amount from Priya, who is she? Spouse of Lalit. So Lalit is a director. He has resigned. Okay, he has resigned from the company, and company received this before his resignation. So this guy has resigned on 15th, and this kind of money has come on before his resignation, 5 days before. So will this amount be treated as deposits? So the answer is that it will not be treated as deposits. No. Why? Because it is clearly mentioned that if the amount in the same rule I have told you 21C, that if we receive money from the director or their relatives, then that amount and the all the declarations have been made, so it has been given that declaration has been made, so it will not be treated as deposit. Next we go on to see a sum has been asked, and sum also has come. Let's see, engaged in Ayurvedic medicines. Okay, they have a good profit. Now what they have said, the company plans to declare bonus shares. Okay, so now the provisions of bonus shares are contained in your section number 63. Okay, what it says is held by the existing shareholders. So how much is the ratio of the bonus? For every 1 share, 2 shares are issued. For so declare a bonus of 1 share for every 2 share held. So if you are holding 2 shares held, then you are getting 1 bonus share. 1 bonus share. So very simple. Now let's see what the question is. The board wants to know, now what the board wants to know, the sources of bonus shares. So again, section 63 says that you can use your from the table. If you see what can be used for bonus shares, okay, from this particular thing, what all can be used. So if you read, your free reserves and security premium account can be used for giving free shares, means you're giving free for the shareholder, but someone has to pay, so we will deduct the free reserves and security premium account. Very simple. Okay, so sources are there. I told you security premium this, and proceeds of issue other issues which have been mentioned. Conditions for the bonus share, so special resolution, board resolution, no defaults has been given. Okay, and the maximum number of bonus shares that can be issued under the provisions of Company Act. So if you go to see, the maximum amount that they have is of 40 lakhs, right? 40 lakhs worth money they have, which can now deposit redemption reserve is a statutory reserve. This cannot be used for issuing bonus shares or dividend. So only this will be used. Now how much shares are, the face value is everywhere they have given is of rupees 10 each. So if they are issuing of 10 each, then 4 lakh equity shares can be bonus shares can be issued. So you can say that the maximum amount that can be utilized is 40 lakhs. Okay, now depending on what price, if it is issued at 10 rupees, then the maximum number of bonus shares that can be issued is 4 lakhs. Okay, equity shares can be issued max if the value is 10. Okay, so this is the amount that you will be used as to determine the maximum amount. Moving next, the board of directors of Greenstone Limited consists of total 8 this much, 2 this, okay, with 4 executive directors in collusion means in fraud, okay, with the auditor manipulated the accounts. Okay, so let's get into the question meant before filed an application before NCLT. Now we are seeing whether the tribunal is the competent authority to entertain the application for few of few directors for removal of the auditor. Now obviously, yes, NCLT is only the body which is entitled to remove and look into the matter. So NCLT has the powers to remove on grounds if it has reasons to believe that there has been a, what they've given you, manipulation of accounts. Will the auditor be eligible for appointed as a auditor of any other company? Answer is no. Very, very simple. So once you are removed by an auditor of tribunal for falsification of accounts, so obviously you cannot become an auditor of any other company. Okay, so the provisions of auditors also you can write. Okay, so your section 141, 140, all those will apply. Now coming to investigation proceedings has begun against this company. During this, they had reasonable grounds to believe that a transfer of funds, assets is likely to take place. It has not taken, and it is likely to take place, and it is prejudicial to the company. In this connection, the tribunal requested the company's legal advisors to disclose and furnish a copy of the relevant communication made by them, but they refused. So the tribunal requested the legal advisors. Now it's a very plain vanilla thing that they should have given, but they refused. Okay, so whether under this wants to pass the following orders. So can they freeze the account? Answer is yes. Can they punish for contravention? Answer is yes. Compel this? So answer is yes. So it was a very straightforward and a very simple provision with respect to inquiry, inspection, etc. So it's Caesar. Now coming to the next one, state whether the following persons are eligible to be appointed as auditors of the company under the Companies Act. Okay, so if you read your section 141, they talk about who all can be appointed, qualification, disqualification. So in that, when you see that when we want to keep an auditor, it should always be an independent party, should not be related to the company. Simple, my company is keeping as an auditor. So the directors of the company want to appoint Keshav, a fellow member of ICSI. Very good, you can keep him as an auditor. We want to, directors of MNO Limited want to appoint Keshav. So Keshav is a chartered accountant. So very good, he can be appointed. Naveen, one of the partners of Keshav firm, has given a guarantee for rupees 1 lakh in connection with indemnity to a third party to the subsidiary. So again, very simple. When you see the threshold is 5 lakh rupees. So if I say I am connected and he has given me 50,000, I am indebted to him for 50,000. It's not accounted. It has to be 5 lakh rupees. So can he be appointed? Answer is yes, because 1.10 lakh is no amount. Here also what they are saying, Aryaman is indebted to the company for this and we want to appoint Aryaman. We can appoint because threshold is 5 lakh rupees. Next is Manoj is a, so here also yes, you can appoint. Then next is Manoj is working as a purchase manager. I want to appoint Vaibhav, husband of Manju, as an auditor of the company. Let's read again. Manju is working as a purchase manager of this. So RTS Limited is there and his employee is Majnu. Okay, Manju is a employee or a whatever. He's a purchase manager and wants to appoint Vaibhav. Manju's Vaibhav is the husband and she is the wife. Okay, husband of Majnu as an auditor of the company. So again we will say that since you are a supplier of a material transaction, you will not be allowed. Okay, so director of S Limited. So she is the director working as a purchase manager in this. Directors of S Limited want to appoint. So you will say that since they are connected or a supplier, in it will affect their independence, so they should not be allowed. Moving forward to the next thing is such huge questions they are asking. Okay, now Rockstar Limited has a registered office in Hyderabad and wants to set up an establishment in Germany. Very good. It has obtained a loan from a German bank. this company is set up in Hyderabad, wants to set up in Germany, and wants to take a loan from Germany and create a charge. Now charges are under section 77 to section 87. Very simple. The company receives, so moment you create a charge, he's taking a loan from a German bank. In the charges section 77 only, they say it doesn't matter if you've taken a loan in India or outside India, whether on tangible or intangible property, you have to disclose to the ROC within 30 days. So the company received a notice from ROC for not filing the particulars of charge. So they made a mistake. We will tell that yes, you have to do. It doesn't matter if it is not there. So the company wants to defend the notice, okay, on the ground that it is not required to register the charge because the assets are not located in India. So section 77 clearly says that even if the assets are in India or outside India, you have to register the charge. So advise the company. So this is the advice and the timeline, etc. Moving forward, Suresh has done his MBA, very good, from a reputed institution of management, okay, and wants to incorporate a private or a public company. So this guy Suresh wants to incorporate a private or public company to start an e-commerce business. Explain him the distinction between the two types of company. Okay, so then we will tell that a private company has 2 members, maximum so many members, cannot go to public, has the following restriction, public company, and this. So then we will explain and we will say considering the above features, he can take his decision. Next is issued and paid up capital of this is 20 crores, consisting of this much of this these many shares of this much face value. The company has 2000 members. Okay, a petition was submitted before the NCLT, signed by 320 holding. So let's see where they are getting into this. 40,000 equity shares for operation and mismanagement. Okay, so under section 240, 241 to section 246 talks about operation and mismanagement, and in that when you read section 244, they tell you minimum number of people required to go to NCLT to initiate a case of operation and mismanagement, that is 100 or 1/10 of the total members, whichever is less. So let's see. Examine the provisions of this, decide whether the petition is maintainable, explain the impact of maintainability of the above. If 160 members who had signed the petition withdrew their consent. First, let me see how many total members are there. So this is important, has 2000 members, and it has been signed by 320 members. So from here, if I take a 100, okay, or 10%, so either ways this is met. So the petition is maintainable because 10% is also how much, 200, whichever is less. So they are very well within the limit, so it is allowed to go for this. Then from this they are saying 160 withdrew. So if it is falling below, then and it is below the thresholds of 244, then it will not be permitted. Now coming to the next one is direct question. What is concept of indoor management with the exception of forgery and negligence as provided? So it's a direct fair question, you can write it down. Then comes a case study. Now question number 5, case study. The name is so innocent, Bunny and Sunny Some Limited, okay, and see Bunny and Honey, okay. See the length of the question. Okay, I'll just take you through the question length. This is still the question only. Okay, question goes on and then they ask answer the following of Bunny Limited. Here they have asked the mode of approval for the investment proposal of this. Identify the authority and the mode of approval. So we'll see investment. Whether the approval of PFI is needed, whether they are exemption if it is a private company, and whether it is an investment company, and whether 1500 shareholders are entitled, to propose the appointment of small shareholders director. Okay, so if you read small shareholders director is under section 151. And is it mandatory for the company to appoint such if a valid notice is received? So let's go through the question quickly and finish it off. So what are they saying? This limit is there. What is happening is Bunny has proposed to invest 80 lakhs in the equity shares of Honey. So Bunny is ready to invest in the shares of Honey Limited. So your automatically your loans and investment section 186 will apply. Okay, they want to invest 80 lakh rupees. So then they have given you the thresholds. You will have to calculate what is 60% of paid up capital plus free reserves, etc. Okay, now coming to the question, which authority? So you will write board resolution and special resolution if the limits are exceeding. Is PFI this needed? Yes, if they made a default, okay, then they will have to take approval of this PFI. Is there any exemption? So the exemptions are in subsection 11. Then comes whether Honey Limited is a investment company. Now investment companies whose business is mainly to invest in security. So in the question also they had given that this part they have said that the total assets are this much and including investment in shares of 200 lakhs. So income derived from investment and this is 30 lakhs from a gross total income of 100 lakhs. So if you go to see, they are saying that there is a test, asset test or income test. If any of this is hit, then it becomes an investment company, okay, as given in your section 186, investment company. So is it an investment company? See, out of total assets are how much? 330 and 200 including, so this includes 200 means it is obviously more than 50%. It completes the test, so it is a investment company. Moving forward, now this, if you see in the particular thing, I had told that they are asking drafts and they asked drafts of 15 marks. If you had joined the dream batch, link is in the description, go ahead, join it. If you have not joined, even for the next papers you go ahead and join. All these drafts are covered. How to draft a board resolution, how to draft a notice of meeting, how to draft a resolution for, all these things, a draft board. So they have asked 20 marks of drafts and they've also asked to draft the minutes of the meeting. Okay. Then you come to question number 6, and question number 6 they have given you the financials and they have said there is a loss, and in the loss they want to pay remuneration to the managing director. Okay, not more than the remuneration, this whatever your maximum remuneration in case of inadequacy of profit without seeking this. So this is a very straightforward question. Okay, from your your section 190. Okay, so 188, 190, then you come to 190. Okay, so this is about your maximum remuneration. Your schedule 5 talks about this, read with section 196. Okay, so these provisions are there which talk about this. 20. Okay. So you can just check the KMP provision, the total, but schedule 5 is there. Special resolution has to be taken. If schedule this is not complied, then you have to take approval of the central government, and in that schedule 5 they have given you a entire table that has to be adhered. Now explain the compliance requirement for holding AGM. Now section 96 talks about AGM, okay, of the meeting, including the listed company as per the provision of Companies Act and SEBI LODR. Okay, so very simple, notice of meeting, giving 21 clear days notice, informing the stock exchange, all those very direct questions have been given with the timelines of when it has to be conducted. Now Rohit, the director of the company, wants to know the provisions of this with respect to inspection of minutes of board meeting. Okay, so your section 118 talks about minutes of the meeting. So minutes can be inspected. It has to be permanently maintained. It has to be it is open for inspection as well. Okay. Then Sunil, a shareholder of this limited, has lost confidence in the managing director. So Sunil, a shareholder holding this much stake, so he wants to know the procedure steps. So again, you will write that he can file a special notice. Special notice is to remove your director or auditor of the company, and he has the requisite stake also. So he can go ahead and file this. He will give a notice. Special notice has to be given 14 days before the meeting. Moment you give it at the company will rotate it. At least they will make a public announcement, and then he will be removed at the meeting if the shareholders approve. So that is it. According to me, the paper was very lengthy. It was very difficult. According to me, one of the most difficult papers. Then next is they are asking everything in it. Okay, all chapters. I had told in the particular strategy video also that don't only focus on meetings and directors. Sometimes if you see operation mismanagement, investigation chapters have come, your mergers and amalgamation, from there also a lot of questions have come. So a strategy should be not to leave anything, to do everything in this. Okay, and obviously drafts has come for around 15 marks. Okay, so I've decoded the paper for you all as well. Wish you all the very best for your other exams as well.